I'd like to come to the topic of timeliness as well, because one of the sharp aspects of the new CAS regime back in 2015 was how you needed to have a resolution pack which was reflecting material changes in the business within 5 working days. And there was the 48-hour rule where you had to produce the resolution pack to somebody from the FCA if they gave you 48 hours notice. And that was one of the drivers for our business in the early days, because technology enabled firms to make sure that that report was up to date and timely, and that they could produce it on demand effectively. So do you think firms have got a bit better at that? Are we still seeing the FCA sending people in at very short notice to ask the firm to produce the resolution pack and check it? Or has the regime sort of settled down a bit, and firms are sort of updating the resolution pack in a timely fashion as part of BAU, perhaps in a way that was hard at the beginning?
I think firms have got more familiar with the requirements, and they understand now that the timeliness and the fact that they need to maintain those resolution packs. I think the 48-hour requirement for firms is one of those things that it doesn't just apply to CAS. It applies to, if the FCA decides that it wants to go in to visit a firm, the first thing they're going to ask for is file reviews, documentation, and they are well within their rights to ask within 48 hours. So it's not just with CAS, it's wider than CAS, but because there's a specific line item that mentions it, it gets a lot of attention. But in reality, firms should be prepared for that in any eventuality, because the FCA has the right to ask for that for any evidence that when they're looking at a client.
Yeah, I think if I remember, that was one of the big shockers of the regime, was that the FCA was being very prescriptive about how timely the firm needed to produce the information, perhaps in a way that wasn't so prescriptive in other regimes before.